Hey, good afternoon, our esteemed viewers, ladies and gentlemen, subscribers and followers of Law Ascent Radio. Thank you for joining us in another exciting, intriguing, and wonderful edition of Let's Talk with Asset Litigation. I remain your lovely host, Barrister David Ono. And today, as usual, we'll be taking up a very important topic, one that is pertinent and in the front burner of Nigeria, in the fact that there are so much security issues in the country, so much that people have now resort to self-help so as to ensure their safety and the safety of their properties and loved ones. Today we'll be talking about vigilantism under the Nigerian legal system. Do you hear that? Vigilantism under the Nigerian legal system. And as usual, we'll be beginning with a story. Today, our story, we have two characters. The first character is called Titi, and the second character is called Johnson. Now, Johnson happens to be my friend, and Titi happens to be the wife to Johnson, Johnson's neighbor. Now, they live in a common compound. And one of these days, Johnson had issues with Titi, and then it degenerated to fight. Now, upon Titi's husband's arrival, he decided to involve the local vigilante of their estate, who arrested Johnson, and they kept him in their own detention, for about 24 hours. And afterwards, Johnson's girlfriend had to come bail him out with the sum of 10,000 naira. Now, Johnson has asked me what were his legal rights infringed and what are the remedies. Now, with Johnson's and Titi's story, we'll use in making an exegesis. By that, I mean an explanation of this topic, vigilantism under the Nigeria legal system, or you can call it vigilantism under the Nigeria laws. Now, we know that the proliferation of vigilante group and security outfits, private security outfits in Nigeria, is not unconnected with the numerous insecurity problems we are having in the country today, as we have the Boko Haram terrorists terrorizing the northeastern part of Nigeria, with the banditry having to rampage the northwestern part of Nigeria, and ethno-religious crisis in Jos and Benue almost ravaging the entire part of the north central, militancy in the southern part of Nigeria, and self-determination and agitations in the southeastern part of Nigeria, with the southwestern part of Nigeria left with ritual killings and incessant cases of kidnapping. With all these high-rated insecurity problems in Nigeria, we have now been posed with the very challenge of whether our police force, the Nigerian police force, is capable of surmounting these insecurity challenges. And it's on this very basis that people resort to forming vigilante groups for their community, and then even states having to enact laws that establishes their own neighborhood watch, otherwise known as state security agencies. Now, under the law, what does our law, or how does our law position this the legality of, or otherwise, of vigilante groups? Now, the law sees it that for you to establish a vigilante group, you must be able, or you must ensure or give guarantee that such vigilante group will be confined to the ambits of the law. That is to say, they will be circumscribed to the very powers of the law. They will be under and subject to the directives and control of the Nigerian police force. Now, if you are able to give this very guarantee and assurance to the local divisional police officer of the police division in your area, then you can be given a pass, or what we will call a permit, to operate a local vigilante within your community. Now, why is it called local vigilante? Because vigilante is only meant for communities, small groups. It can be a street community, it can be an ethnic community, it can be a hamlet or a family-based security outfit. But whatsoever it is, it must be a small unit of security outfits meant for the protection of lives and property within a community. Having discussed this, we now have to discuss policing under our legislative or other as a legislative function. Now, the work of a police is not an everyday commerce, and so for that reason, policing in Nigeria has been legislated upon. Now, under our Nigerian laws, Section 214 of the Constitution of the Federal Republic of Nigeria 1999 provides that there shall be only one Nigerian police force that will be charged with the responsibility of prevention of crimes, detection of criminals or suspected criminals, investigation of crimes, prosecution of suspects, and even maintenance of law and order. Now, these functions of the Nigerian police, aside the establishment of the Nigerian police in Section 214 of the Constitution, the functions of the Nigerian police can be seen in Section 4 of the Nigerian Police Act. Now, what this goes to say is that while it is the responsibility of the National Assembly to make laws, to direct and legislate the functions of the Nigerian police force, it makes it mandatory that there can only be one Nigerian police force and not two. And it is only the National Assembly that has the right to legislate on that very Nigerian police. That vigilante group, just as we had in our story, that Mrs. Titi's husband had to go involved to arrest Mr. Johnson. That vigilante group, for the purpose of that function, that activity they did, they are not the Nigerian police force. And so the question, it calls to question, what they did is, does it amount to trying to prevent crime? Does it amount to prosecution of offenders? Does it amount to maintenance of law and order? The question is that it is only the Nigerian police force that can do all this. And so when you have each dispute with your neighbor, you don't go reporting to the vigilante group. It is the responsibility of the Nigerian police force to investigate and interrogate suspects, investigate crimes and interrogate suspects. The vigilante group that Ms. Titi's husband went and reported Mr. Johnson to cannot and does not have the powers to investigate that crime of assault on Ms. Titi by Mr. Johnson. Neither does he have the power to interrogate Mr. Johnson on the grounds of the accused or alleged offense that he committed. So, by doing so, the vigilante group can be said to have exceeded its powers, as its powers are only confined to the prevention of crimes. And so once crime is committed, they can only step in to arrest the said offender and hand him over to the Nigerian police force. So by detaining Mr. Johnson in their facility, even for just 2 hours, even though it was not up to 24 hours, just 2 hours, meanwhile they had the opportunity of taking Mr. Johnson to the nearest police station. By detaining Mr. Johnson alone, that is an infringement on the rights of Mr. Johnson, because Mr. Johnson, under Section 35 of our Constitution, has the inalienable right. By inalienable, we mean he has the innate right. It is an inborn right. It is a right that comes as a result of his citizenship of Nigeria. He has this right to liberty of person, personal liberty. And as such, when his liberty is constrained, when his liberty is impeded, when his liberty is infringed upon, when his liberty is violated, even though it is for 30 minutes alone, he can go to court to enforce that his right and then seek for damages from whosoever that has infringed on his right to personal liberty. So in essence, the vigilante group having been informed that an alleged offense has been committed, which is criminal assault on Mrs. Titi by Mr. Johnson, does not have the right to go ahead to detain, though has the right to arrest Mr. Johnson, but does not have the right to detain Mr. Johnson. And as such, what they ought to have done is to take Mr. Johnson to the nearest police station immediately after his arrest, because it is only the police that can now investigate and interrogate Mr. Johnson to know if there is a prima facie case. By prima facie we mean if there is, on the face of it, if Mr. Johnson has committed the crime of criminal assault against Mrs. Titi, for which he will be arraigned in court. So it is only the police that has that responsibility to do that. So as a vigilante group, or one that is organizing or heading a vigilante group, it is wrong for that vigilante group to go the extra mile of detaining suspects, having a cell, or imposing fines and collecting what you call bail fees, just like the police will do. Or even though they say in the police force that bail is free, but it is wrong for the vigilante group to have insisted that Mr. Johnson can only bail himself upon deposit of any amount of money, even though it is 100 naira. It is wrong in our laws. No individual is meant to impose fine on any person on the commission of a crime. It is only the courts, and I repeat, it is only the courts that can impose fine on any person on the accusation of having committed a crime. Only the court has the power to do so, not even the Nigerian police force. And that is why they will always tell you in words that bail is free, but in practice they do the opposite. Well, we are not here to talk about how they do the opposite, but just to discuss vigilantism under our Nigerian law. Having discussed this, we'll now go to our vigilante groups legal. Knowing that their functions and knowing the powers they wield, and knowing when they act are beyond their powers, is vigilante group on its own, is it legal? The position of the law is that under section 33 of our constitution, the 1999 constitution I mean, it provides for the right to self-defense. What this means is that every individual has the right to protect himself from harm and has the right to protect his property from destruction. Now, that individual is allowed under the law to take reasonable steps, and emphasis on the word reasonable, to take reasonable steps to ensure that no harm comes to his person, neither does any harm of destruction comes to his property. So, if a person or group of persons, in this instance, decides to come together and form a vigilante group for the protection of themselves so as to prevent harm from happening to them or destruction happening to their property, it can be said to be confined under the provisions of section 33 of the Constitution, which provides for rights to life and rights to self-defense. Also, under our laws, section 4, subsection 6 of the Constitution of the Federal Republic of Nigeria provides that each state of the federation shall have a house of assembly that shall have the power to make laws for the peace, order, and good governance of such states. Now, what this means is that each state of the federation having its own house of assembly. That house of assembly is saddled with the responsibility of making laws for the peace, order, and good governance of that state. And in exercising this power of ensuring peace, order, and good governance, the House of Assembly can take the extra step to legislate and establish security outfits for the purpose of complementing, assisting, and aiding the Nigerian police force in carrying out its core responsibilities under Section 4 of the Nigerian Police Act. What this means is that under our laws, the various houses of assemblies can establish security outfits. For example, the Lagos State House of Assembly sometime in 2015, established the Lagos State Neighborhood Watch. Now, what this means is that this Neighborhood Watch can have all other powers to ensure the prevention of crime, but does not have the powers to detain beyond reasonable time a suspect that is alleged to have committed a crime. 2, does not have the powers to carry out interrogation and investigation of crimes when a suspect is in their custody, as their powers is only prevention of crime and arrest of suspected offenders of crime. And when those offenders are arrested, they are expected under the Lagos State Neighborhood Watch Law 2015 to immediately produce such suspects at the nearest divisional police station closest to the place where such suspect is arrested. So the law does not permit them to take that suspect to their to their office and then put him in custody or in confinement pending investigation and interrogation of such suspects. The law does not permit them to do so. Also, when we talk about the legality of these vigilante groups, which is in the community stage and then the neighborhood watch in the states at the state levels, it must be noted that they are established also under pursuant to the powers granted to the government of a state and the federation at large, where it is stated in section 14 subsection 2 of the Constitution of the Federal Republic of Nigeria 1999 that the primary responsibility of every government shall be the protection and security of lives and properties within their domain. That is to say, the executive governor, as the chief executive officer of his state, owes it as a responsibility to ensure the safety of his people. By his people, we mean persons within his state. And as such, is allowed to take reasonable steps for the purpose of protection of lives and properties within his state. Now, people will ask, you may ask the question, does the establishment of the Nigerian police force under the Constitution, does it conflict with the establishment of state neighborhood watches and establishment of vigilante groups by states and communities alike? Now, the answer here is that the Constitution provides for the Constitution provides for the establishment of the Nigerian police force, the Constitution does not prevent the establishment of other security agencies or private security outfits for the purpose of protection of lives and properties. What the Constitution prevents is the creation or establishment of another Nigerian police force other than the Nigerian police force as stated in section 214 of the Constitution. And that is why you could see the neighborhood watch of the various states, using Lagos State as an example, and even the regional security outfits like the Amotekun and the Ebubago in the southwest and southeast respectively. Therefore, in conclusion, while we have numerous security challenges in our country, no doubt, and while there is need for the security of lives and properties, it should be taken into cognizance that caution should be the watchword of every community that chooses to establish a security outfit, otherwise known as a vigilante group, for their safety. And also states that decides to establish security outfits, otherwise known as neighborhood watch, for the security, to guarantee the security of its indigents within the state. This is because policing job is one that should be done with expertise, one that should be done with courage, and one that should be done with the obedience of fundamental human rights and rule of law. Persons to be recruited as vigilante members by communities must be those persons that the community has ensured, after taking due investigation, that they are not persons that are security threats to members of that community or persons with criminal records. Because once that happens, the propensity of violation of fundamental human rights will be there. Also, states need to take caution and understand that establishment of security outfits, while sanctioned by law, should not be a tool for oppression of political opponents and to be used as a mechanism for political thuggery. This is because when you fail to police a society, you give room for criminality. I hope with this, we have been able to lay out the foundations for vigilantism under the Nigerian legal system, and also ensure to tell you your rights under the Nigerian laws whenever you are being accosted by vigilante groups and neighborhood watches. And also, we have been able to educate you on your rights within the confines of the law when vigilante groups and neighborhood watches act beyond their powers. That means act ultra vires. Note that whenever your right has been infringed, it is not your duty to take the laws into your hands. But the best you should do is to report to the nearest police station, and after that, consult a lawyer for legal advice. And only the lawyer can tell you whether legal action can be taken against such vigilante group or not be a tool for oppression of political opponents and to be used as a mechanism for political thuggery. This is because when you fail to police a society, you give room for criminality. I hope with this, we have been able to lay out the foundations for vigilantism under the Nigerian legal system, and also ensure to tell you your rights under the Nigerian laws whenever you are being accosted by vigilante groups and neighborhood watches. And also, we have been able to educate you on your rights within the confines of the law when vigilante groups and neighborhood watches act beyond their powers. That means act ultra vires. Note that whenever your right has been infringed, it is not your duty to take the laws into your hands. But the best you should do is to report to the nearest police station, and after that, consult a lawyer for legal advice. And only the lawyer can tell you whether legal action can be taken against such vigilante group or neighborhood watch group that has violated your fundamental rights. Please, we would like to hear from you as usual, so ensure to drop your comments, questions, suggestions, and queries on the comment section of whatsoever streaming platform you're watching me from. I will promise to give prompt response to such comments, queries, suggestions, and comments in general. Until we meet again, I remain your host, Barrister David Onu, and I say,